Hi, this is Ali Eliason with EDL 850, Module 12 regarding tort liability. We're going to be talking a little bit about what it is, why it's relevant for us as educators, and how it applies to you. We'll get to look at a couple of real life examples here. So the legal definition of a tort, according to Legal Dictionary, is when someone's actions cause some type of harm to another, whether it's physical harm to that person or harm to your person, property, or reputation. That harmed person can seek damages through the court. So as you're going to see, some of the acts that we were talking about that can be damaging to someone fall under two categories. Some of these acts can be physical, your assault, your battery. They could be verbal, your libel, your slander, defamation, falsely accusing someone of something, or invading their privacy and touching their property. These types of acts require proof of intent, that you meant to harm that person and you decided that that was your choice to make. And the burden of proof lies upon the accuser to prove those kind of things before you can be found guilty. Your unintentional tortious acts go against negligence, a lack of standard of care, breach of duty, and injury. These are very important for teachers because we are required through our job to pay attention to our students, to do our jobs, to care for our students, and to take care of them, especially in medical emergencies, and keep them from harm. These require proof that the injury was a direct result of failure from an educator to take care of a situation or to avoid a situation, actually. So how that would affect you, usually under tort law, the individual teacher is not liable. It is the school district itself and the attorneys, but a teacher themselves usually can still be liable depending on if it was unintentional or intentional and how the civil case is worded. The damages can be decided through the court. They can be awarded as compensation for the loss of damage to the personal property or the physical property, or for a financial loss or damage to like a reputation. So this can be reimbursement of money. This can be medical expenses for injuries, pain and suffering, loss of earning, and wages can be given back, and punitive damages for things that you've caused. So as an educator, I found a couple of real world examples that we're going to look at that make these maybe a little bit more relevant to you. And, excuse me, here's a few legal cases regarding tort for educators. The first one I looked at was a case from 2002 to 2005 regarding Jasmine Oyston. She repeatedly was bullied, both verbal and physical, having things thrown at her, having things said to her that were inappropriate. It happened at a college campus, actually, across several locations, including inside buildings, in classrooms, on a bus, outdoors, and the school contacted them after teachers had been contacted by the student, the coordinator had been contacted by the student, and the school's decision was to refer her out to a counselor. She had bouts of depression, panic attacks, and she actually went in for hospital admissions, including one for self-harm based on these bullying incidents. So the parents' case was that there was a breach of duty, that we as teachers were not properly watching the student and not keeping them in a safe environment, which equates negligence by the school for creating a safe environment for our students. So that's our failure to protect the students. The ethics that would have been covered from that would be, we need to have a commitment to the job to promote safety, security, and acceptance. We need to make sure that we are pushing character education. We are supervising our students and making sure to report those things that are happening, and definitely obeying those school policies. Any school, no matter if it's a zero tolerance policy school or if it's a board that has made their own decisions on how to deal with these types of situations, you have to stick to the rules and policies in place for all students. And with this case, they actually did find that the policies were not followed because the teachers did not follow protocol for how to report these things, and that they were far too lenient on the students that were the antagonists in this case. The school district that I'm at, our steps that we have in place, we have a flow chart that decides if these types of incidents occur, if it falls under a minor or a major behavior, and then what steps to take next. If it's a repeated behavior, or if it's just a one-time, or if it's incidental, who to contact, those type of things. And we keep record of when we contact parents for these. We also have our students that are the antagonists, or someone who perpetrates these kind of behaviors, fill out what we call a think sheet. I know elementary, especially primary, is different where I'm at than what a high school would fill out. But we also have sheets that go across the district that are carbon copied, so that it shows a record of the teacher talking to the student about what had happened, what rules were broken, and how it's going to be fixed in the future. And it is carbon copied with a signature that is by the teacher and the student, and has a space for the kid to take it home and get it signed by a parent. They keep the original, and the school keeps a carbon copy for records, so that if this becomes a repeated behavior, especially in instances of bullying, if it escalates, we have a point system in our district. They can earn more points that will show severity and show a repeated pattern that can lead up to suspension, expulsion, police interactions, those sort of things. And that can be documented, especially from year to year, so that future teachers know what's happening. The proactive things, like I mentioned before, would be character education, talking to students about how to report bullying, and supervision. The major part with bullying goes to supervising your students, knowing where your problem areas are, and having teachers be aware of what to look for these type of things. I know we're not going to catch everything everywhere, but doing your job and not having that breach of duty takes care of a lot of this. Again, reporting methods and record keeping so that we can avoid problems in the future, or at least have a paper trail. So if a parent does go to file a liable suit, or say their kid didn't do it, or there's never been a history, you have documentation in your hand that says these things happen, and you can show them what the school has done to handle these measures. My next case is regarding a 17-year-old student. He was a baseball player who was expelled after making a derogatory sexual comment towards another baseball teammate that was put down as a joke. He had requested sexual favors from a teammate, and they said that it was on a dare. The father of the student that was expelled cited negligence, gross negligence, intentional infliction of emotional distress, civil conspiracy, and violation of the student's rights. Most of this goes to the fact that the student was expelled before the parent was contacted, and that the student handbook agreement that they had, the steps for an investigation, were not followed before the student was expelled, and that the sexual harassment code of conduct actually said that there were other steps that should have been handled before the student was expelled, including witness statements and the history of the student's rights to get to make a statement regarding what he said happened, and the district to get to interview other people that were involved. So that was the parents' contention, that the expulsion went against that agreement. The school district, on the other hand, said that the parents had signed the agreement, everyone had the handbook, and they knew it was possible for that to happen if the situation were to arise. So this went back to kind of a he said, she said. The student did end up getting expelled. It went back and forth in court for a while, stating that the school board gave the students and the family the option to leave the district or go to a different school and withdraw without having an expulsion on his record, and the parents said that that was never an option. The student, they're actually just supposed to get out of court here in the next week or so with a decision, supposedly. So I'm kind of still waiting to hear what's decided on that one completely. The ethics that go with this one is just a commitment to the job again, promoting that safety and security and obeying the policies, sticking with all the rules and making sure it is there for all students. Just being able to have that piece of paper that says, here's our policies, here's how we're going to handle it, here's how we have followed our rules, to be able to show to a parent that here's the steps you're going to take and they know in advance, saves you a majority of these types of problems. I think the gray area that becomes is it was just a joke or locker room talk. Even as you've heard it with our president, becomes a very widely debated topic. So jokes are not always jokes. And as a 17-year-old, you have to kind of make sure that the parents and the students are aware that those things are not going to be condoned or allowed within the district. So our district in USC 305 has a policy. If this were to occur, the principal will inform the board of an investigation and any corrective action that is taken immediately. It is a violation to not complete an investigation. That's kind of where this school district had their no-no, was that they did not complete the full investigation without making a decision. That student is also informed of the report, the one that makes the report, and kept apprised of the investigation as it goes on. So they want to keep everybody in the loop of the steps that are being taken as it goes on. Proactive steps would be, again, that student handbook agreement, being able to show it to parents. Here's where the rule was broken. Here's the steps we said were going to be followed. And also the big conversation, especially with your high school students and your older kids, talking about sexual harassment and sexual assault. What constitutes which one, where the gray areas are, no means no, what can be taken out of context and jokes. A lot of times they don't realize how close they are to being legal adults, and those kind of jokes aren't taken lightly as adults. So once they get close to that, those are conversations you need to have with those students, especially as they get older. And again, I feel like I put this down a lot, is supervision is one of those major things that you need to have a conversation with about with your staff about how to avoid these kind of things. I know this was locker room, but coaches should still be supervising their team, or someone should still be there as an adult to make sure that these situations don't happen. My next case was assault by a teacher, supposedly on a student. This actually I thought was kind of interesting. There is not an assault or a physical component to our USC 305 policies. This is considered bullying under our school policies, that an adult can place a student in reasonable fear of harm. So with this school, the teacher assaulted a 5-year-old student when they were being unruly. The claim is that the teacher grabbed the student physically by the arm, pinched with nails, left bruises, shoved the student into a chair, causing bruises across the chest, and there was crying, and she actually called someone in to help assist with this student. Thankfully, I think for the school district, a lot of what helped them and their liability for this is that once the school administrators found out about the situation, they made the decision to contact the parents to come pick up this child due to their injuries and let them know what had happened, and immediately place the teacher on suspension and leave. So they sent the parent and student away, and they went to the local hospital. The teacher was suspended and reprimanded as a result of this, and I think it did say that there was a review of policies as an entire district for especially special education and restraint and what's allowed. So that goes to my proactive, is training your teachers, what you're allowed to do, what you're not allowed to do. Having someone be your backup for immediate behavior supports. We, in our building, we have a student support coach, now being renamed to our family support facilitator, that we have a chain of command. He's our first person we call. If they're not available, we have 3 other people in line for who will be the person. to help with de-escalation for these type of situations. Sometimes in the heat of the moment you can get upset, but having that training and steps and knowing that you have backup can sometimes help mitigate some of these circumstances. So the ethics that would go with that would be, again, commitment to the job, promoting safety for the students, and obeying the policies. Don't put your hands on students, ever, really, unless you are MANT trained and you are in immediate danger. Usually our policy is clear the room, get the safety of the other students, contain the risk within the room. So our policy is an investigation on this would be open to determine the facts as soon as it's possible to verify the validity of the report of the student. The consequences and actions of a person who engages in this, the superintendent's job is to decide the nature, severity, and circumstances of that act. So there's not really anything in stone that says what exactly would happen to a teacher that would do this. Obviously, they would be placed on suspension, but it's up to the superintendent on whether they would be let go or if there was some sort of training or interim position that they could be placed in. The other case we ran into here was negligence. I thought this one was really interesting, which is why I picked this one. It was the failure to maintain the property that was safe for students in a PE class in Philadelphia. A 9-year-old student ran into an uncovered concrete wall in gym class. So the school was found to not have mitigated risks by taking care of their property. The case, actually, the argument was that the school should have known that the gym was going to be used for physical activity where students would be running and have the possibility to trip and fall into this wall. So they were expected to maintain their property in accordance with that type of activity. USD 305, I think, would remedy that situation properly by padding the wall and close off that area until it was fixed. We would contact parents and give proper medical care as necessary, and also talk to our teachers about how that could have been prevented. Looking for areas within our building, exposed beams, hanging lights, those kind of things. We do have our building operator walk through, so that's something we try to do and being proactive with. And that teacher training on how to avoid accidents and just treating medical emergencies, knowing what to do. I think the court case on this one actually said that was one of the things that they were found to not be, the school was negligent, but the teacher themselves were not. They treated the student immediately. They took proper care to handle the student in the appropriate manner. So the teacher themselves were not, but the building and the district themselves did not maintain the facilities in the way they were supposed to. So that's where they were found to be negligent in that building. The ethics, I feel like I've said this over and over, but it's a commitment to the job, is promoting that safety and security, making sure that you are protecting your students and just looking out for those kind of things, since those little eyes don't always know or have the maturity to look for those kind of things themselves. Finally, I thought this was kind of an interesting one. We had a 13-year-old student who had incomplete amputations of 3 fingers when they were crushed in the hinges of a classroom door. So to me, that sounds like an accident. I mean, I know my 2-year-olds do this type of thing, but the accusation was that the teacher slammed the door and was negligent because they did not ensure the student's safety. The teacher testified that they checked the door, make sure there was nobody out in the hallway, and that everyone was in the classroom. But there were student witnesses that said he had been seen slamming the door on multiple occasions. So the teacher was found not negligent after the jury called this just an accident. They cited the care he gave to a student, that said he went pale, he took care of him right away, he called parents, contacted administrators, and that they didn't seem like there was any intention to hurt the student. The only statement that kind of went against that and contradicted it was that he had been seen slamming doors in the past when the class was unruly and was trying to get their attention. Many said that they didn't think this was the issue, so the court came back and said that this was not a case of negligence in this case. My district would have said that teachers who observe students in dangerous situations should attempt, as they're able to either halt or prevent injury, which seems like this teacher did. They checked supposedly out in the hallway. This teacher gave medical care to the student immediately and contacted with parents. And they had a conversation with the teacher and the student regarding that situation. So as an administrator, I would want to sit down and say, hey, here's what happened. Here's how we could avoid this. Look at how you handled it. What do you think about it? And just really having those conversations to make sure that those things don't happen in the future. So promoting safety again, and knowing that your students matter most. In this case, taking care of the students, modeling responsibility for the actions that you had, respecting your students and taking care of them quickly made a really big difference. So proactive building maintenance walkthroughs, I guess maybe a door stopper or something like that could have kept that from happening. Teacher training just on avoiding accidents and how to treat medical emergencies. This one just seems overall it's hard to be proactive when it's something that's an unfortunate accident, like recess injuries or running into walls. So some of the references I ran into, these were the cases we went through, and the legal book we used, Legal Dictionary, gave you the definition for tort, and looked up our school policies. So hopefully you understand that there is such a wide gamut to run into when you're talking about tort liability, and as an administrator, being in charge of a large number of staff and students in all different areas, whether it be within your building, out on the playground, out in front, on field trips, sports activities. There are a number of things, so it's just knowing how to train your teachers to try to mitigate as many circumstances as possible, how to deal with accidents and injuries when they happen, and reporting policies. Document is so very important, and having those conversations with teachers. So hopefully you learned a little bit today about tort law. Definitely look up your administrators or your school legal team and your Board of Education policies if you have any questions. Hopefully you guys have a great week.